calificas para ser legal. ¿Quieres saber? Solo llama al abogado Andres Mejer.
How much does it cost to remove the conditions on my green card, and how long does it take? How long does it take? Well, that's simple. A year to a year and a half, generally speaking. If you're in removal, it can last 2 to 3 years or 4 or 5 years. It really depends on the circumstances. So how long does it take is relatively simple from beginning to end. If in a normal context, it's 1 year to a year and a half. If you're in removal, it takes a lot longer, and then it depends on the judge, and there's a huge backlog. So removing conditions on your green card depends on whether it's a joint petition, meaning you are still married and your spouse is helping you get your permanent green card, or you're doing a solo petition, meaning you are divorced, you're a widower, or you're suffered extreme cruelty. So in that case, you're doing it on your own, plus you're filing for a waiver. Now, the filing fee for the government is $680, and it is going up, so don't wait. File today if you can. Remember, USCIS has asked for a 10% increase across the board, and Trump has asked to, increase filing fees by some obscene amount. So don't wait. Today it's $680. Tomorrow or in 6 months, God knows how much it's going to be. If you qualify, file today. The cost of the petition itself varies between $3,000 and $6,000. That means this is what we charge to help you or somebody file the I-751. We charge between $3,000 to $6,000. In your typical case, it's a joint petition, no waiver, and interview. That's the normal scenario. Or it's a solo petition, meaning you're not together anymore for whatever reason. You're filing a waiver and you have an interview. Now, you have an interview in almost every case nowadays. Again, historically, that was not the case. We typically charge $1,500 to attend the interview with you. We strongly encourage you to go with one of our attorneys to the interview. But even if you choose not to have us with the interview, we're going to prepare you before your interview either way. But what if your case isn't typical? Well, you will likely have one of these additional issues. First, if we didn't do your initial green card petition and you didn't keep copies of every document you submitted to immigration and every document they gave back, we're going to need to do a thorough background search with FOIA to each immigration agency, there's 7, to make sure we get copies of everything. We don't want any surprises. We want to see everything in advance, preferably before we file anything. Now, we typically charge $1,000 per person for that service. Obviously, for your kids, they don't usually need that. We get it for the immigrant. Now, since it's only been about 2 years, you are unlikely to have a criminal conviction that needs to be reviewed for post-conviction relief. However, you may have pending criminal charges like domestic violence or a DUI. Look, in times of stress, we sometimes make bad decisions. It doesn't mean you're a bad person or aren't entitled to stay in the United States. You have to fight for your right. And depending on the charges you're facing, we typically charge between $3,500 to $7,500, but serious charges will cost you much more. However, what if you or your child weren't charged with a crime, but were actually the victims of abuse? Maybe you requested a temporary restraining order and you're going to have a trial in New Jersey for your final restraining order in a short period of time. Well, in that scenario, we typically charge between $3,500 to $4,500 to help you get your restraining order. If you were charged with a serious crime, you likely are now facing removal proceedings. If we get your criminal charges minimized or dismissed, we can likely get your case remanded from the court to immigration for immigration to interview you. Again, we're talking about the same petition here. What we're saying is you filed the petition, or you need to file that petition, and now you're facing criminal charges either before you filed to remove the conditions, immigration put you in removal, or even after, they still put you in removal because of the seriousness of the charges you're facing. Now, if we make those charges go away, we get them dismissed, or we get them minimized as something that doesn't have immigration consequences, we can ask the judge to remand the matter to USCIS to adjudicate the petition. If we can't convince the judge to do that, then you're going to have a trial. We're in front of a judge. Now, we charge $1,500 to go to each court appearance and $5,000 for a trial. To the extent that we can avoid a trial, we'll do our best to do so, because trials are risky. You don't know what judge you're going to get. You don't get to choose who the government's attorney is going to be, whereas when you're dealing with an interview in immigration, if they deny, they will put you in removal proceedings, but you're not automatically in removal proceedings. You understand? So if we're in a trial scenario and the judge denies your petition, you've now been deported. So the consequences are much more severe. We'd much rather deal with it at the agency level. To the extent that we can, we don't always have that option. Now, do your kids need to remove conditions on their green card? If they do, we typically charge a nominal fee, $500 to $1,000, to include your kids in the petition. It's basic. It's based on you and your relationship. So children is just paperwork, but if you get it, they get it. Now, sometimes if you're denied, they may still get it. Now, even if you aren't filing a joint petition, you can still have any of the issues we talked about before: criminal conduct, divorce, background search, have to include your children. All of that can happen whether it's a joint petition or not. Now, if it isn't a joint petition, you definitely will need a waiver. And we talked about good faith waiver, widower, or abused spouse. For most waivers, there's typically an additional fee of $1,500 to $3,000. With the exception of a widower, there's no fee for a widower because there's no additional documentation we need to provide other than a death certificate. Now, let's go back to the good faith waiver. Guess what? You need to be divorced. Now, there are two kinds of a divorce, and we can help you with either: contested and uncontested. Because we are talking about a marriage of short duration, there usually isn't a lot to fight over. In many of these scenarios, there are no kids and there isn't much money made together. You guys typically have not bought a house. Maybe you've rented a car, maybe you've rented an apartment, but unless there isn't a lot to fight over. Usually the things that people fight over is money and kids, child support, visitation, custody. If you don't have any of those two, then often the parties, we can help you guys enter into an agreement. It's called an uncontested divorce. We agree on everything in advance. We file it with the court. We have one appearance in front of the judge, and that's typically $3,000 to $4,000, and it can get completed in a couple of months. Now, if you guys are fighting about things, well, then it all depends on how many hearings and if there is a trial. But you can expect to pay $5,000 to $10,000. Sometimes your spouse is angry, and what he or she really needs is time to calm down, and we can amicably resolve the situation later on. Sometimes your spouse is hell-bent on getting you deported, and in that case, you have to fight to the very end. So but different scenario now. Good faith waiver, it's either uncontested divorce or a contested divorce, but either way, you need to be divorced, and that's a heck of a problem because you're on the clock. Your spouse is not. So they have leverage whether they know it or not. If you were abused by your spouse or your child was abused by your spouse, you will be filing a waiver. You don't need to wait for the divorce, but you will likely need a divorce at some point in the future. As discussed above, you may have filed for a restraining order and you may need help proving that you were abused in getting that restraining order. Now, we need to prove that you were abused. You likely will need the assistance of a therapist or a psychologist to write an expert report and get treatment. So the requirements are still you entered into the marriage with the best of intentions, but it didn't result because of the abuse, and the abuse has to reach a certain level. It could be physical abuse, it could be emotional abuse, but either way, it must be abuse. Now, emotional abuse is harder to prove. Physical abuse is a lot easier. There's photos, there's documentation, there's medical records, right? So it's not you saying this is what happened to me. You're providing objective evidence that someone kicked the crap out of you. That's not acceptable. Or of your child. Again, it's not just you. It could also be your child. If you're a widower, there is no additional fee. All you need to show is a death certificate and the regular requirement that the marriage was entered in good faith. Now, what happens if you already filed your joint petition, your Form I-751, and immigration issues you a request for evidence or a notice of intent to deny? Well, in those cases, we evaluate why the government says, what problem the government says you have, and we come up with a solution together. Sometimes the government makes a mistake. I know that's a joke, right? Only sometimes. No, they make a lot of mistakes. But in your particular case, sometimes they ask for things that we've already addressed in our petition. I can't tell you how many times I've seen, you didn't provide your divorce decree when we had 3 copies in it, or you need a birth certificate. Again, it's in the table of contents, it's indexed, it's referenced, and they just missed it for whatever reason. So sometimes they make those kind of stupid mistakes, and we don't charge you to deal with those. We just say, hey, take a look at this, but here's an additional copy. We included it in the initial one, but here's another one for your benefit. Again, we don't charge for simple stuff like that. If it requires a detailed response, now how much we charge depends on whether we helped you with this initial petition or not. If we did the work for you, let's say we got you the green card, let's say we filed to remove the conditions on your green card, you're going to get a discount. First of all, because we know your case and we can supplement, and we know that what we do goes way beyond what most attorneys provide. We go into a lot of detail. So supplementing doesn't require a lot of work because we front load much of what we do. So the cost can be from $1,500 to $2,500, but we've had cases where we charge less. However, if you apply for Form I-751 by yourself or with a different attorney, well, now we're going to have to review what was done to prescribe a solution. This is usually more expensive because few attorneys, like I said before, few attorneys go into as much detail as we do. They do very little, and then they respond with more detail if immigration asks for anything. We prefer to provide a ton of stuff up front to avoid the necessity of them asking for more information. We want them to look at it and say, okay, yeah, it's clear to us this is a legitimate relationship, but maybe we have a question on this one issue, right? So now, depending on what that is, we typically charge between $3,000 to $4,500. Why so much? Well, because we didn't do any of the work. Now, it could be less. It's not usually more than that. It's really the high end. But I don't know what I don't know. So I need to be able to review everything that you did or everything that your prior counsel did. Now, it becomes a lot more difficult if you didn't keep copies of your documentation. You didn't use an attorney. You did it all on your own. Now we're really treating it like a I-751 from scratch, where I don't know, I don't have copies of what you have. I don't have time to wait for immigration to give me copies. So I have to just treat it like a brand new application from the get-go and provide everything that you should have provided initially. And again, that's why there's such a big range. Now, one last point. Often, because filing getting the I-751, the joint petition granted, is taking so long, a year plus, what we're finding for a lot of our clients now is by the time their I-751 is approved, they can already file for citizenship. How is that? Well, don't forget, citizenship is Form N-400. Now, in the joint petition context, you can file the I-751 90 days before the 2-year anniversary. So, of when you got your green card. So you've had your green card 2 years. Now, the I-751 is taking a year plus. Well, if you have a green card for 3 years and you're still married to your spouse and you got your green card based on marriage from your spouse, you can file for your citizenship after 3 years of getting it. You filed the I-751, you're still waiting for a decision, you've had your green card for 3 years, you can file for citizenship, and we would encourage you to do that. Now, if you're not together, so it's not a joint petition, your wife passed away, your spouse passed away, you're already divorced, or you were abused, you can't file under 3 years. You have to wait 5 years from having your green card. But I encourage everyone to file for citizenship as quickly as they can. Now, I previously discussed the requirements for citizenship for filing N-400 in a prior program. Take a look at the link below for that video. Now, at Andres Mejer Law, we offer payment plans and we offer discounts for repeat customers. So if we got your green card, if you if you got your green card with our help, obviously I didn't give it to you, right? I just prepared the station and the proofs so that you got it. And you then filed to remove the conditions of the green card with us. And now you want to come back and get your citizenship. You're going to be paying less than anybody else. For the simple reason is because we treat our customers right. And we appreciate loyalty, and we appreciate the fact that you got the results that you did, and you trust us, and you still trust us with your immigration work. So we will reward you for doing that. Now, we do offer payment plans, and we give discounts for those that pay in full. So we will help you where you're at. We'll meet you where you're at. The most important thing in this climate is, hey, don't lose your rights. When you have an opportunity to file, file. If your spouse died, you don't need to wait 2 years, file right away. If you got divorced or you're considering getting divorced and it's not been 2 years, the moment you get your divorce, you can file. You don't need to wait for the 2 years. If you guys are together, don't let the 2 years pass by without filing. No matter what happens, don't let the time pass. It's a real problem because, again, immigration will put you into removal proceedings. So thank you for joining us. I'm Andres Mejer. Until next time.